My name's Curtis Eckmark, and I'm blessed to be the General Counsel for Power Ranch. Now, I'm not one of the litigation attorneys handling this case. The association has other lawyers doing that. So I'm not going to try to speak on their behalf or go over every one of their arguments that they'll be making in court. But what I will do is I'll share some pertinent documents with you and some background information. The first thing that I need to do is explain exactly what happened in 2011. A resident recently posted, quote, "It has now been uncovered that Power Ranch, all caps, approved the land use of apartments at both Woodcrest sites back in 2011, end quote." Now, what was attached to that post was an architectural approval by the Architectural Review Committee for a design change. However, in order for there to be a change in use at Power Ranch, there needs to be an amendment to a tract declaration. And when you look at the minutes, you'll see that the board had an open meeting on September 27th, 2011. The board at that time was made up of people who are completely different than the current board. Yet that board back in 2011 unanimously decided to deny the request to amend the tract declaration. That board back in 2011 unanimously decided not to change the use to an apartment use. The developer at that time respected that decision of the board, and there was no litigation. So if anybody tells you that the board back in 2011 approved this site for an apartment use, you can look at these minutes and see for yourself that the board denied this request, and you should be asking yourself, why is this person saying this? 2019 was an important time in this case because that's when we start to see documents in which the current developer is promising to sell condominium units. And if the developer now goes back on those promises, the association will lose hundreds of thousands of dollars. The developer asked for a meeting with the board, and the board met with him on March 25th, 2019. At that meeting, the developer asked the board for concessions with respect to assessments and the payment of working capital fees. The board agreed and allowed the developer to pay reduced assessments and allowed the developer to pay only half of the working capital fees, with the other half being due when the developer sold the units. And if you have any doubt about whether the developer was promising to sell condominium units, look at the following documents. First are the minutes of the meeting on March 25th, 2019. These minutes show that the developer specifically stated in that meeting that their sales velocity is forecast at 3.5 to 4 years. So there's nothing about rentals in these minutes. The developer told the board it was going to sell these units. Second, the developer signed an agreement on May 3rd, 2019 with the association. The first section, 1.01, states that the developer will pay that remaining 50% balance of the working capital fees when Woodcrest sells a unit or units to a third-party purchaser. Section 1.02 is titled Working Capital Contribution Upon Sale and requires the developer to pay the working capital payments upon sale of any unit or units. Section 1.03 states that the association has lien rights if the amount is not paid at the time the unit is sold. Section 1.04 is titled Working Capital Contribution from Subsequent Purchasers and references buyers who will purchase from the developer. In this agreement, the developer promised to sell units. The board relied on this promise in granting the assessment reduction and deferral of those working capital fees. The third document is the document the developer submitted on June 6, 2019. The developer submitted an architectural application to the association, confirming the promise to sell units. That application references the developer's desire to bring the product current with today's market demands from buyers. The submittal also states developer needs to update the project to include features which are important and popular with buyers in today's marketplace. Again, we have a document in which the developer is saying to the association that he will be selling units to buyers. Fourth, on July 29th, 2019, the association asked developer how many estimated closings would occur in 2020. This shows that the association was relying on sales to generate income for the association budget. Developer responded that 30 units would close in 2020. This is another example of developer promising that units will be sold. So in light of all these promises, you can imagine how surprised the board was when management came and reported in early 2021 that the town had called them and alerted them to the fact that the developer was trying to build an apartment complex. So I'm told at that point in time to send an email to the developer's attorney, which I did on January 27th, 2021. That email states, quote, "As you know, I represent Power Ranch. The last time we interacted, your client was seeking concessions from the board in exchange for building condominiums within the community. The association recently informed me that your client is now attempting to build apartments, in direct contradiction to its earlier representation to the board that the board relied upon. In order to change the project from condominiums to apartments, your client needs approval from the board. Please note that the board has not granted this approval. In fact, the board voted unanimously against it." In response to the email, the developer requested a meeting, and the board agreed to meet with the developer on February 3rd, 2021. And at that meeting, the developer asked permission to change his plan and rent out all the units. He called it a build-to-rent plan. The board's position was that you can call it whatever you want, but what you're really trying to do is operate an apartment complex when you're supposed to be building and selling condominiums like you told us you would. So they asked me to write an email to the developer's attorney, which I did later that day. That email stated, quote, "The board considered your client's request to change the use from condominiums. While your clients referred to the new proposal use as build to rent, the new use classification under the governing documents would be apartments. Although the board appreciated your presentation, the board voted unanimously against the request. Thus, the board is insisting that the owner proceed with the condominiums as currently contemplated," end quote. So, on that day in history, February 3, 2021, there's no doubt that the developer knew that the board was absolutely not okay with the developer renting out all the units. The developer knew that in the eyes of the board, this build-to-rent plan was not in accordance with the governing documents that require condominium use. So, later in February, I'm asked to check with the developer, so I write an email on February 27th, 2021, asking, "Are you doing condominiums?" Keep in mind, at this point, the board had already made it clear that it did not consider renting out all the units to be a condominium. Yet on March 1, 2021, the developer's attorney emailed back and said, quote, "The answer to your question is yes," end quote. On April 30th, 2021, the developer submitted a document to the town of Gilbert. The town had also questioned the developer because it was starting to wonder whether they were doing an apartment. In response, the developer told the town, quote, "The proposal is for a for sale condominium plat." Now, they didn't say a condominium plat, they didn't say a for rent condominium plat. They specifically told the town that it was a, quote, "for sale condominium plat." In a later phone call and email exchange between me and the developer's attorney on June 28th, 2021, the developer's attorney again confirmed that, quote, "The intention remains to build a condominium as opposed to apartments/rentals." And then on July 7th, 2022, the developer's attorney again confirmed to the association via email that the plan to do condominiums has not changed. So, time after time, the documents show that the developer was promising to sell condominium units. Now the developer wants to go back on those promises and sell none of the units. Why is this important to you? I don't want to speak for the board, but as I understand it, they had two concerns. First, there will not be a single person in those 120 units with pride of ownership. And second, the association will suffer significant financial losses. Specifically, the association will lose that other half of the initial working capital fees that the developer had promised to pay when it acquired the property. That alone is $45,000. Second, the association will also lose all the current working capital fees that should be paid when the developer sells these to purchasers. That is $2,500 times 120, which is $300,000. And the association will also lose all the future working capital fees on resales in perpetuity. That is a lot of money that would go into your reserves or reduce your assessments if the developer would honor those promises to sell the units. And as I understand it from the litigators, a big question in this trial is going to be whether the court estops the developer from going back on these written promises. Estoppel is a legal term that a court says you made a promise that someone else relied upon, and now you're estopped or prohibited from changing your position. So the litigator's goal is that the court will make the developer honor these written commitments to sell the units so that the association does not lose this significant revenue. So I've heard the developer speak quite a bit about the declaration, the CC&Rs, but I've never heard him mention Section 6.1. And Section 6.1 is really important because that is the section that distinguishes between rental apartments on one hand and condominium units on the other. Now, Power Ranch has what's called a land use classification system, in which the original developer went around and recorded different tract declarations for each of these different areas. And these tract declarations are what tells us what a certain property can be used for. The tract declarations are what tells us the use of any particular property in Power Ranch. So in this case, the tract declaration requires that the property be used for condominium development and for, quote, no other purpose. This means that use for anything other than a condominium is a violation of the tract declaration and therefore a violation of the master declaration. So, this is a condominium. The developer has to stay within the boundaries of that particular use according to the tract declaration. So how does the developer want to use this property? The developer wants to own and rent all the units. In other words, to the neighbors, this will be exactly like living next to an apartment complex. What does the developer himself say about this use? In an interview with the Alliance, the developer stated, quote, "It is clear to me that Woodcrest East does meet the definition of rental apartments." And that makes sense because Section 1.45 of the Declaration defines a rental apartment as a situation where one owner rents out 4 or more units in a single building, which is exactly what the developer in this case plans to do. So the question becomes, the key question for this case is whether a rental apartment, as the developer has admitted, is within the scope of condominium use, which is the only use allowed by the tract declaration. In other words, are rental apartments within this box that is condominium use? Well, in every condominium, there are only 2 types of property. The 2 types of property in every single condominium are common elements and condominium units. Those are the only 2 types of property in a condominium. So in order to qualify as condominium use, a rental apartment would have to fit into one of those 2 categories. Now, I'm not aware of the developer arguing that his rental apartments are common elements. And that wouldn't even make any sense if he was arguing that, because common elements are things that are shared in common, like the roofs, the walls, the pools, etc. So, what this boils down to is whether a rental apartment can be a condominium unit. Because if it's not a condominium unit and it's not a common element, it's not a condominium. So, this is where your master declaration, section 6.1, becomes really important. Because what 6.1 does is it explains that rental apartments cannot be condominium units. The reason is that your master declaration at section 6.1 allocates completely different membership allocations to to rental apartments on one hand and condominium units on the other. And logic tells us that two different types of property that are allocated two different types of memberships cannot be the same. So under the master declaration, rental apartments and condominium units have different memberships, different voting rights, and pay different assessments. These differences make it impossible to say that rental apartments are condominium units. So let's go to section 6.1. Section 6.1 is the section that allocates memberships. 6.1a states that all lots get one membership. What's the definition of a lot? In section 1.34, the definition of lot specifically includes condominium units. Thus, all condominium units get one membership. Now, let's look at rental apartments. Rental apartments, unlike condominium units, are not included in the definition of lot. Why? Because they have their own separate category in section 6.1b, not A, B. 6.1b says that every owner gets one vote for every 4 rental apartments. So, let's take this project of 120 units. If this project is really truly condominiums, they would have 120 memberships, 120 votes, and 120 assessments. However, if it's rental apartments, it only has 30 votes, 30 assessments, and 30 memberships. Obviously, those aren't the same. I went to law school to avoid math, but I can tell you that 30 is not the same as 120. And because 30 is different than 120, it is impossible to say that rental apartments are condominium units. Because 30 is different than 120, rental apartments are different than condominium units. So, I'm not the one who decided this. The board didn't decide this. The litigators didn't decide this. The original developer of Power Ranch, back when they recorded the declaration in 1999, made a conscious decision that rental apartments were not condominium units. And this makes sense because rental apartments do not need their own votes because they're owned in bulk. Condominium units, on the other hand, need their own votes because they're supposed to be owned by different people. So to summarize, the property has to be a condominium. Okay? Condominiums contain only two types of property: common elements and condominium units. Rental apartments are neither. Rental apartments are not common elements, rental apartments are not condominium units, and what that means is that rental apartment is not condominium use. And once it's not condominium use, once it's outside this box, now that means it's in violation of the tract declaration and it's in violation of the master declaration as well. So, under the Power Ranch declaration, rentals, like many things in life, are fine up to a point. Under this declaration, that point is when one owner rents 4 or more units in a single building. At that precise point, the use no longer qualifies as condominium use, and the developer would need approval as an apartment development in order to do that. So I've heard that the developer talk about how this project is similar to another project that he has called Bella Victoria. Now, obviously Bella Victoria is not in Power Ranch, not subject to RCC&Rs. However, when you go to his website, what you can see is that on his own website, he refers to Bella Victoria as apartment homes. Now, I've also heard the developer say that he is hiring Mark Taylor to manage the project. When you Google Mark Taylor, you will see that they are apartment managers. And this makes sense, right? Because when you own all the units and you refuse to sell any of them and you rent them all out, what is the difference between that and an apartment complex? I think if you ask 100 people to look at 2 projects and you say this one over here on the left is owned by one company, but you can't buy over there, you can only rent. And then you say this other one over here on the right is there's a few units in there that you can rent, there's a few units you can buy. I think every single person is going to know that the one on the left is an apartment and the one on the right is a condominium. Because that's what makes a condominium unique, right? What makes a condominium unique is the fact that you have different owners living under the same roof. You have different owners living within the same walls, and you have different owners sharing common amenities. That's what makes it a condominium. That's why Black's Law Dictionary defines a condominium as, quote, ownership in common with others. A single real estate unit in a multi-unit development in which a person has both separate ownership of a unit and a common interest along with the development's other unit owners. So who are the other unit owners in this situation where the developer plans to own every single unit? This is why the Arizona Condominium Act defines a condominium as, quote, real estate, portions of which are designated for separate ownership, and the remainder of which is designated for common ownership, end quote. Common means shared, and when there's only one owner for an entire complex, there's no common or shared property. And when there's no common or shared property, there's no condominium. The entire purpose of the Condominium Act is to regulate the relationship of different owners sharing property in the same development. None of this makes any sense or has any meaning when a single owner owns the entire property. I know the developer took some condominium documents and recorded them against this property. My question is whether this magically transforms the property into a condominium. If an owner could say that property was a condominium just because they recorded a piece of paper, then what good are the other restrictions in the declaration? If that were true, a developer could record a condominium declaration and then use the property as a hotel, a homeless shelter, or even a prison. It seems to me like the recorded documents should have to bear some resemblance as to what is actually happening at the property. In this case, the developer recorded documents that talk about a board being elected by owners, talks about notices to owners, talks about assessing each of the owners, talks about penalties for not paying your assessments, talks about fines for the governing documents, talks about a time when the developer is going to relinquish control of the association. I could go on, but you get the point. None of this stuff applies when one person owns the entire property. The document they recorded actually says that the owners need to go through an alternative dispute resolution process if they want to sue the developer. So in this case, what that means is that the developer wakes up one day and decides he wants to sue himself. Then he will have to get a vote of himself. He will then have to mediate with himself before he can arbitrate against himself. You get my point. This document has absolutely nothing to do. It has no bearing to the reality of how this property will actually be used. As many of you know, the developer filed a counterclaim against you. Instead of just letting the court decide whether or not his plan was legal, he made the decision to sue all of you. You should also be aware of the efforts the board is making in trying to make sure that the developer will not suffer any damages. Specifically, the board voted unanimously recently to not take any type of enforcement action against the developer until this case was completely and finally over. Therefore, if the developer wins, then the developer will have gotten to do what the developer wants, and he will continue to get to do what he wants, which is rent out all the units. However, if the association wins, then a court will have conclusively determined that the developer does not have a legal right to do what he wants to do. And so based on this action by the board, the litigation attorneys drafted an email to the developer's attorney asking that he dismiss the counterclaim. The developer refused. So now the litigation attorneys have drafted a motion for summary judgment on this issue. The developer's response is due soon, and the court will hear arguments on this issue at the end of August. In this case, the board had a very difficult decision to make when the developer refused to work this out and just filed a declaration. The board voted unanimously to file suit, and they turn this matter over to the litigators in order to do so. But I have never heard the board say that they're not willing to resolve this case through a settlement. To that end, the board tried mediation. The board tried a formal settlement proposal after mediation. And I want to be careful here. I don't want to speak for any of the individuals on the board because they all have their own individual feelings. But the gist I get is that the board is willing to work with the developer if he's willing to compensate the association for the revenue that it will lose if he goes back on his promise to sell the units. Keep in mind that the developer filed a disclosure statement with the court in which he stated he would make $6 million if he sold the units, but he would make an additional $12 million if he rented them all. So one question is, if the developer can really make that much more money renting the units, why doesn't he offer the association any of the money that it will lose as a result of him not selling the units as he previously promised? I want to thank you for taking the time to review some of these documents that I talked about today. I know the board wants to be transparent with the owners. Hopefully, you'll feel that that happened today. And personally, I'm happy to do whatever I can to get this resolved. I can't control the developer. I obviously don't have a vote on the board. But if the developer wants to meet with me, I'm happy to sit down, meet with him, and try to bridge any gap with the board if I can.